Who can be my power of attorney? Hey there, my name is Ron Payne. I'm the CEO and managing partner here at Payne Law in Kernersville, where we help families navigate life's important decisions. And one of those important decisions that families need to make is who's going to be responsible for paying the bills? Who's going to be responsible for healthcare decisions? Who should I pick? And a lot of times clients ask us, well, who do I pick? Or they think they have to name the same person for everything. So first, let me answer who you can pick. The only requirement under state law to be a power of attorney is that you have to be a competent adult. And what that means is you have to be an adult, so 18 or up, and you have to be competent, which means that you're able and willing to make those decisions. There's not a lot of requirements beyond that. You can pick anybody you want to. And competency doesn't mean that they're Albert Einstein or anything like that. It just means that they've not been adjudged incompetent. They've not had their rights to make their own decisions taken away. Because if they can't make decisions for themselves, then I guess it'd be hard to make decisions for you. And so other than that, you can pick anybody. The typical power of attorney, whether it's healthcare or financial power of attorney, in North Carolina separates those into two separate powers of attorneys, but you can nominate the same people. So most people's structure looks something like, I want my spouse to be my primary power of attorney, healthcare and financial, and then usually they're going to nominate children to be the backup power of attorney to their spouse. Now, you can nominate the same children in the same order for all of the powers of attorney. So you could say, I want my spouse to be my power of attorney, financial and healthcare, and then I want my oldest child to be the first power of attorney for both, and then I want my second child to be the backup power of attorney for both, and I want my third child to be the backup power of attorney for both. So then you've got 4 names on there. And the way that usually works, unless you choose otherwise, is your spouse has the only authority to act on your behalf. Unless your spouse is not able. Maybe, y'all were on a cruise ship together and it sinks to the bottom, then and you're in the hospital. Because if you're dead, then powers of attorney don't work anymore. But if you're both in the hospital, then it would go to the oldest child to make that decision. And then it would go to the next youngest child. So it's not concurrent. It's not at the same time. It's one, then the other, and then the other, unless you name them specifically and intentionally co-powers of attorney. Usually that's not typical. That's not what we usually recommend. Because if they can't both agree, then maybe nothing gets done. If the hospital gets dual instructions that aren't consistent, they're just going to sit there and wait for a court order to tell them what to do, and that's not what most folks intend. So now, you don't have to name the same people in the same order on all of your powers of attorney. Let me give a good example. So in my family, I'm the resident attorney in my generation for the age group, and so oftentimes somebody's going to want me to be the durable power of attorney for their whatevers. However, I am not healthcare. I do not wish to make healthcare decisions. I do not like being in hospital, so maybe I'm not the best choice. Lucky me, one of my cousins is a nurse. And so if somebody wants healthcare decisions made, they don't usually call me. They call her. And so if you've got one kid who's more squeamish, then they might be, but they're good with numbers. Maybe they're your financial power of attorney, your first one. And then your first healthcare power of attorney is that kiddo who's a nurse, or maybe they work in the healthcare profession, and you know that they won't have a problem making any difficult decisions or appropriate decisions and listening to the doctor, and they'll be able to keep a clear head. And then you say, well, I've only got 2 kids, so if something happens to one of them, then the other one can be both powers of attorney, right? So if I have to be the healthcare power of attorney, I'll do it. I'm just maybe not your first choice. Likewise, my cousin, the nurse, may not want to be your first choice for financial power of attorney. I'm sure she's great with her money, but she's got a lot more knowledge in the healthcare sector. However, if I'm not available, then she would do a great job and she'd be willing, then she can be the second and the backup power of attorney. So sometimes you'll have one kid who's better for financial, one kid who's better for healthcare, and then if something happens, then they're each the backup for the other. So that way, if 3 of the 4 of you are on the cruise ship and now you're in the hospital, then all of a sudden the remaining child at least has the authority to act on mom and dad's behalf or on your behalf, however you set it up. So again, the requirements for a healthcare power of attorney are just that they're a competent adult, requirements for a financial power of attorney, that they are a competent adult. If you have any doubts about whether or not they should be able to handle something, then our suggestion usually is if you've got a nagging gut feeling, maybe you're not sure if they'd be a spendthrift, then you either can put appropriate limits on their decision making, where you kind of set the outer parameters and maybe you set them a little tighter, or you just pick somebody else. And that's okay too. Nobody has a right to be your power of attorney. You are allowed to pick whoever you want to make your healthcare decisions for you and your financial decisions for you. If you'd like to talk to the team about your power of attorney, or we maybe need to see it, we would be honored to do so. Our estate planning consultations, and that's where this falls under, are free. We offer a free 30-minute estate planning consultation, and we'd be happy to meet with you via Zoom, in person, or via telephone, whatever works best for you. You can set one of those meetings up with us at no cost by reaching out to us on the web at applepaynelaw.com, or give us a call at 336-281-6928, and we'd be happy to meet with you and see how we can help. I hope this has been helpful. We look forward to meeting with you and your loved ones, and until then, like and subscribe here on YouTube, and take care and have a great day. Thanks.